Good afternoon, everyone. Thank you for joining today's Sustainabloom webinar on the H-2A visa program. We're happy you're with us. My name's Amanda Solliday, and I'll be the moderator today. I'm a doctoral student in horticultural sciences at NC State University, and I'm part of the Sustainabloom research team. We planned this session today to help small and medium-sized growers understand the basics of the H-2A visa program, help you make informed decisions about seasonal hiring, and also share free resources on the topic. After the presentation, we'll be opening up the webinar for Q&A, so feel free to submit your questions through the Q&A feature or the chat at any time, and we'll answer as many questions as we can throughout the hour. This session is being recorded, and we'll also share it through AFE's YouTube account. Through YouTube's accessibility features, you can access closed captions in other languages, which is something that I didn't know until we were rehearsing for this webinar. It's very cool. Our expert speaker today is Meagan Kirchner. Meagan is the founder and managing attorney of Kirchner Law. It's a Virginia-based immigration law firm that serves clients nationwide. With over a decade of experience in business immigration matters, she focuses on helping U.S. employers navigate the H-2A and H-2B visa programs to meet their temporary and seasonal workforce needs. Before we jump in, I want to emphasize how the Sustainabloom program is designed to help you It's designed with the purpose of meeting you wherever you are in your sustainability journey. And this kind of hiring program might not be right for you at this time, but we hope it can provide education and insights on the topic so you can make informed decisions in the future. And with that, Meagan, welcome, and thank you for presenting today on the H-2A visa program.
Thanks for that introduction. As she introduced me, I'm Meagan Kirchner. I have been doing immigration law for over a decade, and I'm happy to talk about H-2A today. We've got a good agenda here. Hopefully you get some useful information out of it. The objectives really, we want to just go have a brief overview of the entire program, give you a good idea of what kind of important things you need to know if you are an employer in this program, what kind of obligations you may not be aware of, the everyday compliance, common pitfalls and process missteps that a lot of employers may make and how to avoid them, as well as some practical tips on the steps you can take to make sure your season goes as you want it to and workers get here on time. Again, here's some information about my firm. We really specialize in both H-2A and H-2B, the H-2B is a sister program for the non-agricultural work. And I really specialize in both programs right now, and it's my main focus. And it's really my favorite area of immigration that I've worked with over the past, 10, 12 years. I live in a rural area, so really understand the importance of the program, nationally. So really, what we're going to go over today is the H-2A program. Many of you probably are aware it's our only temporary program that's specific to agriculture. It's limited to up to 10 months per season as it stands today. It allows you to hire foreign nationals as of January this year from any country. There was previously a country-specific list, but the common areas are crops, farm activities, nursery and greenhouse production, certain areas of livestock, and that's really the primary areas. There are some nuanced areas that may also apply. Careful to get into not get into the H-2B side, which is going to be your commercial side. All of this has to happen, on farms or, directly tied to the agricultural side of it. When you get into installations, plantings, things like that, that are going to be at client sites, that's when you may bleed over into that H-2B area. Unlike the sister program H-2B, there are no cap on this visa program. So it's not a situation where you start the process, learn about it, and then find out at the very end when you're almost to the finish line that you don't get workers. It's not as stringent and competitive as the sister program H-2B. It's really in this industry, seasonality isn't just you're planting and you're growing or greenhouse production. It can be market driven as well. So what maybe you're thinking of holidays, Mother's Day, large orders or surges for landscaping demand. So maybe your season, if you're growing, in a greenhouse, is going to be tied to because it's a controlled area. It may be tied to how your end product. So that's an important thing to learn to know about in this process. It's not necessarily as rigid as if you're planting strawberries in a field, things like that. Um, who can use the H-2B program? Historically, there's been a lot of individual growers and producers. That is when the actual fixed site employer is sponsoring the workers directly. So that's going to be when, if you are, as your small employer, small mid-sized employer, you are doing all the labor processes. You're handling the housing, you're handling transportation, all of the compliance requirements that I'll talk about a little bit later falls on that individual grower and producer. The entire process, you may work by yourself, you may work with the assistant attorney or an agent, which, given the nuance in this new administration, I highly recommend, at least until you get used to the program. What's been a growing percentage of H-2A is farm labor contractors. And that is a situation where it's an entity that recruits, hires, employs, furnishes housing, arranges transportation on behalf of you, the actual user of the workers. So while that isn't that takes care of a lot of the logistical challenges if you're working with a farm labor contractor. The farm labor contractor is ultimately the one that is responsible for all those compliance items that we'll talk about later in housekeeping. In most instances, though, when it comes time to be audited or deal with a site visit, all those compliance factors, most times the government's probably going to find a situation where you're actually a joint employer with farm labor contractor, or there'll be joint liability for making sure that the farm labor contractor and the workers were in compliance with the program. So while it can make filing easier, it can be a lot less administrative burden on the individual grower, especially small and mid-sized businesses. It's important to know that you're not just totally off the hook, and you need to know that you're working with a reputable farm labor contractor. Because you're going to potentially be on the hook for that compliance and all those legal requirements. So while it can be very helpful, just take it with a caution, some caution. Joint employers or cooperative associations. This is a group of employers who may share a pool of workers. It's two more entities that really are directing control. They're handling payroll, nature of the work, training, etc. It's intended to allow multiple employers who may not have a full-time schedule. Full-time is 35 hours, at least 35 hours a week for each worker. So it allows you to share all of that compliance burden while being able to take advantage of the program without having to have full-time work that you're solely responsible for providing. And that'll become clear why it's more important a little later when I talk about some of the compliance with three-quarter guarantee and wages, housing, things like that, and because that can kind of ease some of that burden and costs. But again, also some measure of risk to that, because you would be jointly liable and responsible for compliance with this other joint employer. So it's important to make sure you're working with someone you trust, someone that you can trust to, tick all the compliance boxes and treat everybody fairly, both foreign and domestic, and so that you're not liable for something that's really beyond your control. The H-2A process. It's a multi-tier process. You deal with multiple government agencies, state agencies as well, beginning with the job order, which is with the State Workforce Agency, and filing the ETA 790 with the U.S. Department of Labor. This is all things that's done online for the most part. It's in a very time-sensitive process, so you have to file this job order 60 to 75 days before your start date of need. If you miss any times in this process, it's going to push back your start date, push back worker arrival. And so it's very critical to really plan this out. The next step temporary labor certification, also filed with the Department of Labor, can only happen after you completed any deficiencies, filed the application with the state workforce agency, done all your housing inspections and things like that. So those are all tied to the Department of Labor. Once you get a certification, then you move on to the next government agency, which is USCIS. So that's when you file what's called the I-129 petition for non-immigrant worker. Um, H-2A and B are unique in that you can file for what we call unnamed workers, meaning if you, as the employer, are requesting 5 workers, you don't have to know who those workers are at this stage in the process. You are just certified as an employer, having done the recruitment necessary in the earlier steps with the Department of Labor, testing the labor market, proving there's no qualified U.S. workers willing to take the job. Once you get that cert, that's what that certification means. You take that certification and can apply for 5 unnamed workers. That you can also do what's called an in-country transfer if you already know workers. Maybe they work for another farm. Maybe you have met them in some other capacity. You can transfer them with the same petition at USCIS by naming the workers. So you would have 5 named workers that you transfer over that may already be in H-2A or H-2B status that you can transfer. Um, Once you have that petition, if you filed an unnamed petition, you move on to the Department of State. That's where you conduct consular processing, which is where the workers that you select, we complete paperwork to get them scheduled for an appointment at the U.S. consulate in their home country. Um, this process, the timeline will really depend on where you're pulling workers from. If you're looking at recruiting from Mexico, which was the most common in this situation, those workers are going to be usually 2 to 3 weeks, as it stands today, with the delay in getting them, from approval date to when they'll actually arrive, which is again why these earlier timeframes really matter, because you want to make sure you're getting them there as close to your start date of need as possible, so your entire season or harvest or planting is not delayed. Um, Typically, this process is done depending on whether you're working with an attorney or an agent. That process is largely going to be outsourced to someone that's in the home country. For instance, I work with a very common worker facilitator that will help you recruit workers so they can do the recruitment side, screen workers for you. You can interview them, things like that. But they also complete that paperwork I talked about with Department of State. So you're not having to deal with language barriers and make sure the guys get from their home village to the consulate, so on and so forth. That process is done for you in most instances. And some seasoned H-2A employers will ultimately take that over themselves, but I don't recommend it just because there's so many things that go wrong in that process. Determining seasonal need. So as I said earlier, the process is temporary and seasonal in nature. Employment's tied to a season event pattern. And very, very important for this process, which is where some, we talked earlier, some parts of agriculture are left out of the H-2A program because it cannot be a year-round need. If you're, planting, cultivating or having certain crops that were year-round, which again, that doesn't happen often here with when you're tied to a particular kind of crop or planting. This really leaves out poultry or certain livestock. So common things you can use to qualify are weather cycles, certain planting, harvest schedules, like I said earlier, market demand and production peaks, such as Mother's Day, Easter, things like that may dictate when you're producing certain crops or certain species of plant. So that's a very critical component. And in this kind of industry related to planting and floriculture, it's not going to be something that's really going to be extremely challenging to prove. So it's not something that you should be really concerned about. That is an important component that's just good to know. Timeline and planning ahead. I talked about the key steps a few moments ago. Here is where it kind of you can see that why it takes so long. So you really start your conversations with an attorney or an agent 120 to 150 days before the start date of need. That's because each step in that process, you need to get all the requirements done ahead of time before you start your application. Have your dates of need set up, your job descriptions. You need to know your housing addresses. licensing for all of the vehicles, safety inspections for the vehicles. You're required to have workers' compensation insurance. All of that needs to be set up ahead of time. Um, and housing and recruitment take time. If you don't already own housing or have properties on the farm, out on the site, then you need to arrange for housing. There are ways to help facilitate that. There are entities that can help find you housing and make sure it's compliant. Um, One part of the process, I say, there's safety inspections here. So the housing is a requirement for the H-2A compliance. Again, I'll talk about that in a few moments, but that can take time depending on what state you're from. Every state workforce agency is a little different. Steps are required to get housing inspected, backlogs for getting housing inspected, how responsive the staff is can vary wildly. So when you have to file the first step in the Department of Labor process 60 to 75 days ahead of time, and you haven't been able to get housing inspected, and you have to file the second step, um, no less than 45 days before the start date. If you haven't been able to secure those inspections, your insurance, transportation ahead of time so you can disclose it on the application, then your entire process and all the deadlines are missed and it delays your worker arrival. And that can be catastrophic to your season depending on how flexible your start date is. So it's very important to really take the time to plan ahead. If if people call me all the time, I need people next month. This is I can't find local workers. My crops are going to rot in the field. That's not the time to try and set it up. It's just going to be impossible. There's not really a way to facilitate that kind of need. It's really a very proactive process. Um, Now, H-2A benefits. What most employers will find is, you've been struggling to recruit locally, or you have local talent that you hire, but they're very short-lived. You've got a constant revolving door of workers that are there a day or two if they ever show up at all. So it gives you some sense of reliability. So, if you've been unable to scale, unable to expand, maybe you take fewer orders, you just can't produce enough because of you're limited by your workforce. This can be the ticket, the key to really having meaningful change in that respect. You also, especially in this administration, I'm sure you've all been seeing the news, legal compliance with labor laws and immigration is paramount right now. It's site visits from ICE, Department of Labor, wage and hour is skyrocketing. So if you've been relying on local labor that's not documented or doesn't have proper work authorization, you may already be experiencing, maybe you've already been visited, or maybe you've had, that workforce that's been reliable for 5 years and shows up every day and is happy to work, suddenly not coming because they're afraid to show up. This solves that problem. Like I said, predictable staffing during your peak time. Like maybe you're historically have had a good core a group of American workers, but you can't fill that additional need during your peak times. This really can solve that problem as well. It's tied to the first point, but it's a little different. Reducing turnover and training costs. You're not going to have constant, like I said, a revolving door of different people coming in that don't know what your work expectations are. They don't know your standard operating procedures. They don't know your safety procedures. They may not have proper certification. So you may not have to go through constantly trying to recertify someone, depending on what your training needs are and your certification needs. So because these workers, a lot of employers, once they start in the program, they bring the same workers back every year. That's when you read the news stories where they say, H-2A and H-2B are just so beneficial because they've become family. I know it's scary cliche, but I do have lots of employers where this is the case. They've had the same core group of 5 or 10 guys for years, and they know what to expect. There's no training curve. It's very predictable and stable. As I mentioned earlier, supporting business growth and stability, that's really a way to ensure you get you have the means to meet the orders. You have the means to expand your production and add another facility or add another field or another greenhouse. It gives you that ability to do that because you know someone will be there to be able to take care of your product. Um, those are really the key benefits that I hear a lot of time. Costs. As you know, it's a government-run process. There's a lot of red tape. There are objective costs and kind of intangible costs associated with the process. I don't ever sugarcoat that. It's while you have all those great benefits, you also have, there's a cost to that. Government and legal fees are going to be a substantial monetary cost. You've got um, they change year to year, but I'm happy to explain what those are. But, you know, just say we're picking a scenario. If you're doing an unnamed petition and you're a large employer, it's about $1,000 in government filing fees. If you're a small employer, it's a little less, 760 bucks or so. When you're doing DOL certification, it's $100, per employer plus $10 a worker and max $1,000. That's currently paused, but while they're trying to facilitate an electronic means for charging that. But so if you Google it and say, well, that's not a cost anymore, it's just on pause right now while the government tries to kind of figure out the administrative side of it. Housing, meals, and transportation, that's not going to be a fixed cost because it's going to vary depending on where you're located. H-2A does require you to provide the workers housing. It can be shared housing, but it does have to be inspected, there's a checklist of certain things that each facility has to have, running water, bathroom facilities, certain number of beds per square feet, things like that you're gonna have to comply with. Meals are required. You either have to provide them meals or you have to provide them, adequate cooking facilities in order to produce their own meals and give them transportation to and from the store so they can actually happen. Because a lot of these farms may be remote, so they need to have means to get to the store to get groceries. Transportation, that is required both at the beginning and into the process. So inbound and outbound transportation from point of origin. So that may have some per diem associated with it, from their hometown to going through the consular process. That's 3 or 4 days. So there may be some hotels associated with that. And then you're inbound. If you're coming from Mexico, it's usually a bus. It could be sometimes airfare is a little cheaper. If you're coming from Guatemala or El Salvador, somewhere like that, you're going to be having to use a plane. So inbound and outbound transportation at the end of the contract is required. The burden is on the employer. Additionally, transportation if your housing is not on site, you've got to provide them transportation to and from, the work site or the field. If you've got multiple greenhouses, multiple fields, you've got to give them transportation during the workday. Consular fees, those are those fees to fill out the actual individual workers' applications with Department of State at the consulate in their home country. Those are about $205 right now. There's something called the Visa Integrity Fee that is going into effect soon, but they have not for H-2A told us whether the burden of that cost is going to fall on the employee or the employer. We'll find out that in the next couple of months. So keep that on your radar if you're looking at, specking out total fees. There may be an additional consular fee. Administrative burden for compliance. So a lot of small employers may have current work staff on 1099 or maybe you issue paper checks and no payroll. You don't have a payroll system. H-2A is going to require you to have a payroll system or of some sort. There's some H-2A specific ones that are out there. It's specific to the industry. You can use Gusto or any of those off the shelf, QuickBooks, those kinds of things, but you have to have certain things on that payroll. They're required to get pay stubs every week. It needs to have hours offered, hours worked, there's certain line items that need to be on that payroll. Other compliance items, tracking all the costs, making sure you've done the consular reimbursements or paid the consular fees directly, paid the transportation. So there's a lot of record keeping that goes into it. Your agent or an attorney can help you make sure you're in order, make sure you're filling out your I-9s correctly. All of those kind of compliance items, you can get assistance with that if you're filing with a full service agency or attorney. But there is that's kind of an indirect cost that you're going to have associated with it. All of these costs are borne by the employer, unlike other visa areas. Not the employee cannot pay any of these fees. If you're paying a recruiter, make sure you're using a reputable recruiter. Recruiters cannot charge workers a headhunting fee. It's not something that it's for the benefit of the employer. So Make sure you're having workers sign an attestation that they didn't pay any fees. Make sure that you're signing something with your recruiter that they're not going to charge fees. They understand they're in compliance. Department of Labor keeps a nice long list of reputable recruiters that you could turn to. And I have plenty in my toolbox for referral as well. Um, H-2A compliance, all of the, I've kind of touched on many areas of compliance, kind of explaining the process, but here are the big ones. You need to make sure you have accurate job orders and contracts. So, any deductions, any benefits, hours, piece rates, hourly wages, all of those need to be specified in the job order, job duties, job work location. So everything that's kind of in that pre-planning process. That's why that part is very important because if there were to be a site visit or inspection, what they're actually doing, where they're doing it needs to match the job order or the contract. It's very important. Any misalignment there can result in issues with future applications, fines, penalties. There's lots of different ways that could go wrong for you. Housing inspections, again, make sure you're getting those done in timely fashion. Make sure you're kind of broadly aware of what those requirements are before you start the process, and when you're in that pre-planning stage, so that when you go to get the inspection, you're not hit with some ugly surprises. I talked a minute ago about payroll and timekeeping. Time clocks are very important. Keeping records of those, for 3 years, very, very important. Again, there's lots of very good technology out there you can use to assist you in this process. If you kind of work from paper time cards right now, or paper checks, there's ways to modernize that are not too burdensome on the employer to get set up. So it's just important if you decide to file on your own, make sure you're doing all these items. Wages are very important. Make sure they're at or above what's called the AWR. That is set by the government. It varies state to state. It's kind of up in the air right now what that's going to look like next year because there's been some ongoing litigation for a 2024 rule that was changing how they've historically handled the AWR. So again, that's where an employee, an attorney, or an agent can be very valuable to know, okay, what am I going to be in for? They're going to be tracking trends, policy changes, but the AWR is critical. If you're paying, again, piece rate, wages need to be at or above that totality of what that hourly AWR is. Really, really important. Related to wages, you've got corresponding U.S. employees. So if they've got U.S. employees that are employed doing substantially similar jobs, they cannot make less than the H-2A worker. It's very important that what the AWR is and that everybody in that position is treated fairly and receiving the same kind of benefits and wages. Audits and site visits are possible. So all of these compliance items, they're not just suggestions. Don't take them lightly, especially with this new administration. They're being very, very strict. You may get a site visit for an I-9. That's, reviewing the immigration paperwork, make sure you're, participating in if you're participating, you verify that all your workers, actually have work authorization. You may get a site visit from USCIS. They've got a fraud detection unit where they're going to be reviewing. A lot of these units kind of have overlap in what they're looking for: payroll, wages, worker recruitment for U.S. workers, which is part of that earlier process. My apologies. So worker recruitment, U.S. recruitment is very important. So that's an important part of the process. Up until halfway through the work contract for your season, you do have to continue to recruit for U.S. workers and interview them as necessary. Cannot decline them in favor of the foreign workers. Only can refuse to hire them for a lawful reason, or if they're not interested when you talk to them, they don't want to interview after having applied. So all these items are just so very important right now, and I cannot emphasize enough how important it is to follow them. But with a reputable agent or attorney, they're going to give you a step-by-step instructions on how to do that. Now, housing and transportation, like I said, employer provided housing is required, and that does require either provisions of meals directly or adequate cooking facilities in which to create their own meals. Daily transportation to and from work sites, that's going to need to be in a inspected, approved vehicle. It's going to require your drivers to have adequate licensure and insurance. And inbound and outbound transportation and travel have to be reimbursed. And a lot of employers will just pay it up front. That gives you more greater control over how much it costs. Um, in this particular area with H-2A, I haven't had a lot of employees try and book a ticket that's direct or in a business class or something like that. That really isn't something I've seen, but it is possible. So having a little more control over that, or having your recruiter schedule it for you, and then you reimburse either the recruiter or pay the cost directly through that kind of assisted process, can be a way that you have greater control over that and just keep adequate records associated to anything that's related to reimbursement. Um, Wage and work rules. Again, at the outset of the process, we can look over what the adverse effect wage rate is, also called the AWR. That's going to be required as your minimum wage, essentially. That's going to be what dictates what your U.S. and foreign employees in the same job are going to be making during the season. In most localities, you're not going to have issue with what we talked about in a second about corresponding U.S. workers. It's related to that AWR. That's what I talked about a few minutes ago with corresponding U.S. workers. Any substantially similar job can't be paid less. So very important to make sure you're looking at your payroll. One common thing I've seen that may come up where that just not intentional on the port side of the employer. Maybe you hire college students. They only work for you a couple months during the summer, so you pay them, $12 an hour, whatever the case may be. They are doing the same work. They may have less skill potentially, in your opinion, but it is doing the same. They are doing the same work. So make sure anybody doing the same work, regardless of skill level experience, is not paid less than that AWR rate. With the way U.S. wages have been inflated and the market value, it's not as much of an issue in many places, but certain rural areas, it can still be problematic where maybe the AWR is a little more than what you're paying your U.S. workers. If it's one or two workers, it's usually not problematic. But if you've got 10 U.S. workers all making less than the AWR and you have to increase their wages in order to hire the foreign workers, maybe the cost benefit analysis doesn't work out in your favor for participating in H-2A. So also important kind of broader picture things to consider when you're looking at the program. The three-quarter guarantee is something very important to the program, meaning for every work period, you're going to need to calculate total work hours. So for every period, pursuant to the work contract, if you're offering 35 hours, you have to offer them at least three-quarters of those hours to be compliant with the contract. If you're 40 hours, three-quarters, 40 hours. That is very important as far as, how the season works out. And it doesn't necessarily, there's any blocks of time that you calculate that guarantee. And the reason they have three-quarter guarantee versus a flat, every week has to be 100% 35 hours is if you have outdoor work, sometimes you can't do it that week. Maybe there's a hurricane, if there may be some level of impossibility or impracticability and practicability to actually do the work exact same hours every week. This is kind of taken with there's some nuance to it. So it's hours offered. So if you offer them 40 hours, but they're sick or they are traveling or they have family emergency, that's why hours offered is important to track so that you have made it clear to them that you've offered the hours. You keep record that they've chosen not to accept them for whatever the reason is. That's another record keeping thing that can be very important. So if you have a payroll audit, you can show, hey, yeah, it was short this week, that week, but here's the reason why. Again, wage rules, no deductions for visa placement or visa replacement fees. So you're responsible as an employer for covering those costs. Common pitfalls, filing too late. I've emphasized this several times during the presentation, but keeping track of those timelines and filing deadlines is absolutely critical because missing any step in the process can jeopardize your entire season. Because if you're behind in one step by 2 weeks, the entire process gets shifted back a few weeks. You get approved and then you can't schedule consular appointments, until you're approved. That whole scheduling is back, 3 weeks, right? So make sure you've got adequate housing and inadequate housing, either on the basis of what is available in the housing as far as space, number of beds, not meeting inspection, requirements, not having enough housing for the number of workers you plan on sponsoring. All those things are important to kind of suss out when you're in that planning stages because it's difficult to scramble and find new housing with the way the housing market has been recently to, at the last minute. That can again add to that filing too late because now you have to figure out how to fix your housing problem. Um, wage issues can be problematic. Be sure you're looking at what everybody's doing, and then how much they're being paid. Inadequate record keeping. So if you do have the unfortunate circumstance to be have to do a site visit or 9-9 audit, or something like that, wage and hour investigation, make sure your records related to compliance and worker hours, all of those items that we talked about, make sure that they are up to par. Whether you keep a binder, electronic file, some employers will keep both. They'll have electronic file that's easily accessible that can be produced very quickly. Just make sure you're keeping all the records in somewhere that is organized, can be very quickly turned over in the event of an audit or an investigation. Because what you don't want to happen is have them show up and say they need the information in 3 days and you've got it stored in 4 different places, different offices. Some are electronic, some are paper, and you're scrambling to get it in order. Keeping proper record keeping can be very, very helpful in the event of an audit or a site visit. If you are, talking back to the earlier portion of the presentation, if you are filing a joint application or working with farm labor contractor, it's important to coordinate your filings, your dates of need, what hours and duties there are, because if you've got, an itinerary or something like that based on which field or is going to be ready at a certain time, that's an important part of the process. Is just coordinating with who you're filing with. Also, again, making sure you're filing with reputable other businesses or farm labor contractors so that you're not liable for some sort of violation that you didn't have full control over. So vetting that, your colleagues or who you're working with can be very, very important in this process. Now, our legal services, we are a full service firm. We can help with arranging recruitment. We can help with learning about the entire process, start to finish, kind of vetting what your needs are, how it's going to work with the program, whether you should really file as a solo individual filer, whether it's beneficial to have a joint employer, or whether maybe you're working as a farm labor contractor. Maybe you are not a fixed site employer and you work at multiple farms, providing services, help you get spun up in that process, get you through the certification process as a farm labor contractor. We can also assist with aligning you with worker recruitment or consular processing, facilitator. We're every application with Department of Labor, USCIS, getting you set up with Department of State. That's all things that we can help you with. And, if we come in halfway through the game, it can be more difficult, but if it can't, we can still help in certain circumstances. We provide compliance support. So, it's not a matter of, the workers getting here and, we say, goodbye, thanks for talking to us. Good luck with the workers for the year. We provide you with help making sure you're getting compliance done correctly. If once you start payroll, we're happy to review it and make sure you're hitting all the right boxes. We're happy to help you. You are, as the employer, responsible for doing the I-9s. We're happy to do, an audit to make sure that they're completed correctly and bounce them back to you if something's been incorrect. So it's really a full service start to finish, like planning, strategy, the actual filings, all the advice that comes along the way, as well as, providing support after filing or in future years, because the compliance window is, a 3-year look back. So we'll help you, make sure that you've got everything you need for the future as well. And future filings, make sure you're starting the process on time. As long as you're filing with us again the next year, we'll say, hey, it's, 120 days out, it's time to start the process for next year. And sometimes there's some overlap as well. So maybe your season has, depending on the length of your season, maybe you're not done with your prior season when it's time to start for the next season. So we track all those timelines for you. If you're using, um, the same workers year after year, we'll track we can help track their passports, things like that. All those kind of logistical issues that you may not think about. And any reputable agent or attorney should be doing the same thing. Um, Important if you're not aware of it, Sustainabloom has fantastic H-2A and H-2B resources. Really breaks down a lot of what I've talked about in the presentation today, but kind of in a quick, concise manner. So, you can read it at your leisure. I encourage you to do so. It's a great supplement to everything I've talked about today. It may help you review stats, common filing procedures, has good frequently asked questions. Will also provide updates on the program that's constantly changing, especially with the new administration. So I highly recommend using it as a resource, regardless of whether you decide to file yourself, with an attorney or an agent, or some mix of the two processes. So, really important resource, and I do encourage you to seek it out if you haven't already. Thank you today for Sustainabloom and American Floral Endowment for having me. I've really enjoyed the opportunity to talk to you about this today. I will stick around after the presentation, have a nice question and answer that hopefully can answer any lingering questions or uncertainties that you may have after what we've talked about today. And feel free to follow up after the presentation as well. You can refer back to my website or my contact information, or the guide that I talked about a moment ago, and it may help clarify any questions you have.
Thank you for a great presentation, Megan. I already see a couple questions coming in. Feel free to submit more. Before we actually jump into our Q&A, I wanted to share a little bit more about the resources available through Sustainabloom. So on our website, you can find industry guides like the H-2A guide that Megan mentioned, assessment tools, certification information, funding opportunities, and more. And this is all provided free to the industry through our generous donors. So it's a wonderful opportunity to check out things in a low pressure situation. And we're always looking for industry spotlights, and these are also free and open for everyone to submit. They can be stories about successes, challenges, and other experiences related to sustainability. And you can find these industry spotlights and more information on the website at sustainabloom.org. We'll be sharing that through the chat. And with that, I am happy to open up the Q&A, and let's see what additional questions the audience has today. Excellent. Our first question, James would like to know if Hatch Act experiment stations can hire H-2A workers. So these are typically government or university research stations.
Right. So whether or not you can hire H-2A is going to be based on, still be a very employer specific question. So likely these stations or these farms are going to need to qualify independently for the H-2A. And I'm not familiar with the exact requirements, that if there's any stipulations tied to that funding. If there's no requirements or regulatory rules for what they're allowed to spend the funds on, or what percentage of workers need to be U.S. workers, or if there's any restrictions on foreign workers, those would need to be sussed out independently related to the actual funding, if there's, like I said, anything tied to that directly. But as far as H-2A, it would be business as usual from an employer standpoint. You would meet everything I talked about for what qualifies, what doesn't. Proving the season, things like that would be equally applicable regardless of where the funding is coming from. I just can't say for certain if for that particular funding, if you're, looking at the contracts or program requirements, if there's any restrictions on where that personnel needs to come from, or if there's any background checks, things like that.
Okay, great. James, if you have any additional questions, feel free to submit them in the chat after that explanation. Thank you. Thank you for your question. We also had a question about CEU credits if they're offered through this webinar, and unfortunately we can't offer CEU credits at this time. Let's see. Okay, we have another question from Lindsay. Do you have a ballpark figure of how much it would cost for an attorney when you're handling these filings? Her example is for two H-2A workers, but I imagine there are other size businesses that are interested in that question as well.
Right. And with a lot of the H-2A applications, most attorneys, and if you're looking at agent facilitators, typically charge a flat fee. So the number of workers really isn't going to be impactful because the paperwork is going to be the same regardless. When you're looking at um, consular fees or transportation or housing, those things are kind of going to vary based on the number of workers that you're dealing with. But the applications to the government, as well as legal fees, are going to be flat regardless of the number of workers. Most attorney fees that I'm aware of kind of are in the ballpark somewhere between 4 and 6. I'm usually on the lower end of that, especially for a small employer, just because while it's the same sometimes the first year we can work something out that just is it's usually a fixed flat fee regardless of the number of workers. There's very few situations where it's going to really vary based on the number of workers. Sometimes for additional complexity or if the workers are doing like a change of employer where you need a lot of worker documentation and maybe that worker has done a lot of transfers. So we have, 2 or 3 years of history to prove, then it may vary a little bit. But I would say if you're looking at most attorneys, it's going to be in that range. And then, of course, you have the government filing fees as well and consular fees, so which I talked about earlier. You might find some agents that are non-attorneys that will file for less. Just be sure you're working with a reputable one because sometimes you really do get what you pay for. I won't say they're all bad. I'm well acquainted and have worked and talked with. There's some great people out there that aren't specifically attorneys, but they're not. Sometimes they're not less than attorneys either.
Good to know. I have a question. I was wondering what happens if an employer isn't complying with these H-2A rules? What's what's the process for that?
So a lot of non-compliance is going to come up through either a USCIS visit, they have a fraud detection unit, or Wage and Hour has units that go out. So that's with Department of Labor. If you're found to be non-compliant, depending on what they're looking at, there's going to be different penalties. You could have certain violations come with a set monetary penalty, a civil penalty based on what the violation is and how many violations there are. You could be debarred from the program, so it may be that you can no longer file an application with Department of Labor. If you have a USCIS visit and they find certain things to be non-compliant, either fraud, misusing the program, charging workers fees that they shouldn't have been charged, that can result in revocation of both existing and prior applications. And so that can impact your ability to file in the future, as well as impact your prior filings. And that's just not a situation you want to be in. If you're not paying workers the correct wage, they can be charged back wage penalties. So you're going to have to pay anybody who hasn't been paid the proper wage back wages, which depending on how many years of violations you're looking at, that can be fairly substantial. And a lot of times that's paired with money penalties. The other penalties that are repercussions would be potentially civil litigation. Most of the time when we're looking at these kind of violations, they're going to be related to payroll. Like I said, not paying their correct wage. U.S. recruitment is a big one. So if you're not taking the proper recruitment steps or you're not responding to actual U.S. applicants, anything that's going to disparage U.S. workers in favor of foreign workers is going to be a severe problem. Now, I-9s, that's another thing. Everyone is going to have to fill out I-9s if you're hiring, even if you don't have foreign workers, you should have an I-9 on file for all of your U.S. workers that aren't, 1099. Violations for that can be steep. So, making sure you're doing that is a very important step. Some employers have decided to, use E-Verify to kind of mitigate the issues related to I-9 audits. Let's see. The other common violations are going to be, housing or, not providing meals, which could result in any number of those, penalties we talked about.
We have a related question. Lindsay was also wondering what
Mhm.
role or how much support you would offer if there was an audit.
So if there's an audit, it just depends on what kind of audit it is. Typically, we try to do proactive self audits throughout the process to make sure if there is an audit from one of these agencies, we've got everything on hand to very quickly produce to the government. And so I'll typically, if there's someone shows up at your doorstep and they're looking for something, most officers are pretty agreeable, especially if you're polite to say, "Hey, here's my attorney's contact information. Please reach out to her with with any questions." And I'll kind of serve as the intermediary point of contact, so you're not working directly with the government agency. Kind of act as that filter. Um, if we get something like a revocation or something that's just a misapplication of law or a misapplication of fact, maybe they're saying there's fraud, but there wasn't actually fraud or something like that, I will either directly assist with the response and file it on your behalf, or if it's something like I've got a case right now that's just talked to, a dozen attorneys, none of them ever seen this issue before. But one of my clients just a very lucky guinea pig for a new government issue in the H-2B context. In that context, I will generally tie in outside counsel with your permission, and I will handle all the case specific things related to your case. And if we need someone to really be a bulldog and it's almost like pre-litigation tactics where you're kind of throwing in arguments about why the government is applying the law in a way that they shouldn't be doing. We'll tie in outside counsel for that, but I always will give you the option of whether you want us to work together, which is usually what happens because I know the facts of your case, and then they'll just provide assistance with something that's related to the misapplication of law. If it's like a worker specific issue, not just a business audit, then sometimes I can help with that as well. But if you've got a worker that, say, got a DUI or, overstayed the visa or something like that, then that's a case where I will generally refer the worker's issue out because my specialty is on the business side. I don't handle a lot of that, what we call crimmigration or, asylum or humanitarian issues. So if it's worker specific, generally I'll just refer out, but I will do my best to find a contact local to where you are, but I don't generally help with those kinds of worker-based issues.
Great. Thank you, Megan.
Mhm.
We also have a question about transportation. Are employers required to just have a vehicle available for the workers, or do they need to provide a driver as well?
That will depend on the situation. If you do have workers that are able to get a driver's license, which most are, especially if they're coming from Mexico, they just need to be able to pass whatever your state-specific driving test is. Some states will even provide those in Spanish. So if they're able to get a license, you can provide a vehicle, but they will need to have medical exams and be in good health to drive around to the other workers. So I've got some that will have vans available for them and some that will have a worker that is available to drive them around. It's kind of a mixed bag, but we'll look at compliance based on the fact pattern of the specific situation to see which is going to be a better fit and help you navigate that process.
Great. These are all good questions. Keep them coming. We still have a few more minutes. We have a question from Allison. She was wondering if you've seen that it's common for home country consulates to get involved around worker rights or housing.
For the consulates in the home country, not specifically. Most consulates, they do have offices, say in Mexico, that have question or points of contacts for workers that are going to be entering H-2A or H-2B, so they know their rights. They know, that's really to prevent, paying a wage that isn't fair or having them, 10 guys to a room with one bathroom, think egregious situations like that. I haven't seen an issue of it where a consulate will not approve a visa or have an issue like where they step in. Now, worker rights groups in certain states will certainly step in those kinds of situations, if a worker has a problem. Pennsylvania and New York are pretty big for that. There are specific, rural worker, farm worker, or migrant worker nonprofits that will help workers if there's some sort of situation like that. But did I miss that? Did I misunderstand the question?
No,
Okay.
I think you answered it.
Okay.
Yes. Yeah. Another question for first-time employers, does it
Mhm.
take more than that 120, 150-day window that you mentioned to start? Or
Not usually. If we're a situation where you're not a fixed site employer and you're going to need to get approved as a farm labor contractor, so this would be a case where maybe Your business provides services only on farms, but they're going to be going around to different farms. You don't have a particular one place where you're going to be providing services. In that case, if you need to go through the red tape of getting registered as a farm labor contractor, getting your bond, doing all the registration, getting all the medical exams for your drivers and, things like that. In that case, then yes, you would need to start early. So a non-fixed site employer would absolutely need to start earlier just because you do have to complete that extra step. But that's not really going to apply for most employers. So typically that 120-day window is going to be sufficient.
Okay, great. We had a question submitted in advance. So if a small farm doesn't have housing on site,
Yeah.
what options do they have to meet the H-2A requirements?
Yeah, so either way, they're going to have to be inspected. So they're really, and every state kind of calls these things a little different. You've got either, owned housing, which is where the employer would have it, or, public facilities, which would be like your apartment building or hotels, things like that. Some employers can look at, and that's going to kind of where those meals come into play. If you're doing like an extended stay or a hotel or something like that, and you can negotiate, a favorable rate for the guys during the contract period, you do have to consider, whether that like extended stays usually have kitchen facilities, so that'll cover that requirement for meals, and then you have transport for groceries. But you will have to provide meals if, say, you're just using a hotel or you're using something that's, bunkhouse that doesn't have its own kitchen facilities. That's something that is possible. Now, if you're looking at, I know the housing market's pretty tight in a lot of localities, so this is a big sticky issue. Sometimes there's short-term rentals you can look at, or like I said, apartments, but there's also some services that employers can look to that help, kind of popped up in the past few years to help these kind of short-term visa employers negotiate favorable rent and utility, or not utilities, but rent and furnishings, things like that for shorter periods of time, because some of these seasons are quite short. Or even if they're a long season, it's 9 months or something, your season is really that long, you're still on the hook for those 3 extra months. So there are, and I'm happy to provide recommendations for some that I know, but those are some things that people have turned to, that because their job is usually there's a small finder's fee for kind of locating and sourcing the housing, but they help get it furnished. They will help negotiate a shorter rent. If your location, if a 12-month lease is actually cheaper on a per head basis, they'll let you know, like, hey, in your area, we can negotiate a 12-month lease, and it's going to be cheaper than it is if you get, a 6-month lease. So there are certain industry specific solutions that have popped up in the past few years, but I'd say, there's always something you can do. So I wouldn't say that that's, going to be a non-starter for everyone. And that's also where a farm labor contractor can be helpful for a really small filer that maybe doesn't have their own housing or doesn't want to deal with the paperwork. That's where utilizing or working kind of jointly filing with a farm labor contractor can help handle that administrative side. For you. So for truly like, one or two grower, that may be the best fit. Short of places that have housing on site, that's generally easier.
Okay, great. Thank you. Surprisingly, I don't think we have time for any more questions.
Oh,
The hour went
okay.
really fast. I want to thank everyone for joining us today for another session in our Sustainabloom webinar series. We encourage you to subscribe, and it's where you can hear about more webinars like this and additional resources as they're published. We already shared the link in the chat. We also ask that you complete a brief survey after today's session. The survey will pop up as you exit, and please suggest additional topics. Let us know how we can continue to improve these webinars. Thank you again for joining us, Megan. Thank you everyone else for being here, and I hope you all have a great day.
Thank you for having me.